Welcome to this deep dive. Imagine you are promised a life-changing inheritance in a will. We're talking about a massive windfall. But due to a simple drafting error by the testator's lawyer, you lose $75,000.
And, keep in mind, we're talking about a case from 1961 here. So,
Right, so $75,000 was an absolute fortune. It was the equivalent of over $700,000 today.
exactly. It's a huge loss.
Now, naturally, you are furious. You want to sue that lawyer. But here is the catch. You never actually hired them. Can you sue a professional for breaching a contract that you were, never even a party to?
It is a really brilliant puzzle. And here's where it gets really fascinating. Let's say you do get the right to sue them. What if the mistake that lawyer made was on a rule of law so notoriously confusing, so historically convoluted, that even the smartest judges in the country admit it's an absolute nightmare?
That is exactly what we're digging into.
Right. Today, we're going on a journey through a landmark 1961 California Supreme Court case called Lucas v. Hamm. And we're going to look at two major turning points in the law. First, how this exact scenario completely shattered the old rules about who is allowed to sue over a contract. And second, what happens when legal professionals are forced to deal with impossibly complex doctrines?
So let's start with that first concept because it feels counterintuitive. How could someone who is completely outside of a contract, someone who didn't sign it, didn't pay for it, wasn't a party to it, possibly have the right to sue the lawyer who drafted it?
To understand how revolutionary this case was, we have to look at how things used to be. For a very long time, the law relied on a strict concept called privity of contract.
Privity of contract.
Yeah. Basically, the rule was that if you and I make a deal, only you and I can sue each other if things go wrong. An outside party couldn't just swoop in and claim damages. And there was a famous older case in California called Buckley v. Gray that strictly barred beneficiaries from suing a lawyer for a botched will. Exactly for this reason. They didn't have privity, they didn't hire the lawyer, the deceased person did.
Which makes sense from a protective standpoint. I mean, if anyone remotely affected by a contract could sue, lawyers and business owners would be facing endless, unpredictable liability.
Precise.
But in Lucas v. Hamm, the court decides to completely challenge that older Buckley precedent. So let's look at what actually happened here to prompt such a massive shift. Let's analyze Lucas v. Hamm. First, what are the legally dispositive facts?
Okay, so you got this guy, Eugene H. Emick. Eugene Emick is the testator, the person making the will. He hires an attorney named Ellis Hamm to draft this will and set up a trust.
And his instructions are clear, right?
Very clear. He wants a provision leaving 15% of the residue of his estate to a specific group of people, the plaintiffs in our story. Hamm takes the job, writes up the will, and Emick eventually passes away.
But the trust doesn't hold up. Hamm drafted it negligently. The phrasing he used violated a couple of major legal doctrines, specifically the rules against restraints on alienation and the dreaded rule against perpetuities.
Right, and because of this drafting error, the trust completely fails.
But this next part is what really gets me. After Emick dies, Attorney Hamm actually contacts the plaintiffs in writing, tells them the trust provision he drafted is invalid, and advises them that they will get absolutely nothing unless they agree to a settlement with Emick's blood relatives.
It's quite the bold move. He essentially tells them, I messed up the document, it's void, so take whatever pennies the family offers you, or you get zero. Yeah. The plaintiffs are backed into a corner and forced to settle. They ultimately receive $75,000 less than what Emick explicitly intended to leave them. So, rightfully frustrated, they turn around and sue Attorney Hamm for breach of contract and negligence.
That takes some nerve on the lawyer's part, but it sets up our core legal showdown perfectly. And what was the core legal issue?
The central question the court has to answer is, can intended beneficiaries of a will who lose their testamentary rights due to the drafting attorney's failure to fulfill his contract with the testator recover as third-party beneficiaries, despite a lack of direct privity?
Right, because remember, they have a complete lack of direct privity with this attorney. They never paid him a dime. So what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
This is where the California Supreme Court officially overrides that strict privity barrier from Buckley v. Gray. The rule has two elements. First, the main purpose of the contract must be to benefit the named third persons. And second, the promisor, the attorney, must understand the promisees, the testator's intent to benefit them.
So it's not enough to just accidentally benefit from a contract. The entire point of the contract has to be about helping you.
Exactly. And the court drew heavy inspiration from the insurance industry to make this policy shift. They cited cases like Walker Bank and Trust Co. and Johnson v. Holmes, Tuttle Lincoln Merck, where banks or auto dealers promised to secure insurance but failed. When accidents happened, courts let the injured third parties sue those companies because the contract's entire reason for existing was to protect them.
Thank you. Now for the court's elemental analysis, let's walk through this step by step. How did the court apply the first element, the main purpose, to benefit the third party?
So, the sub-issue here is whether the benefit to the plaintiffs was express or merely incidental. The defense tried to argue it was just a remote, incidental benefit. But the court applies the fact that the entire purpose of a contract to draft a will is to effectuate a future transfer of an estate to named beneficiaries.
I mean, that's literally why you hire a wills and trusts lawyer.
Right. It's the whole point. So the court concludes that the first element is easily met. It is entirely improper to characterize a testator's intent to leave money to someone as a remote benefit.
Understood. Now, what about the second element, the promisor's understanding of that intent?
For this element, the sub-issue is whether the attorney needs a specific outward manifestation of intent to be held liable. Hamm's defense relied on older language from business cases like Smith and Fruitvale, arguing that the promisor must clearly manifest an intent to secure the benefit.
Basically saying, hey, we didn't explicitly promise the beneficiaries anything, so we aren't liable.
It's exactly. But the Supreme Court disapproves of applying that rigid standard here. The sub-rule they clarify is simply that the promisor must understand the promisee's intent. Then they apply the facts. Any attorney drafting a will inherently and unmistakably understands that their client's whole goal is to benefit the specific people named in that document.
You can't exactly draft a document saying, give 15% to these people, and then claim you didn't understand the client wanted to give 15% to those people.
Right, it defies common sense.
Yeah.
So the court concludes this second element is also entirely met.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing all of this, the court concluded that intended beneficiaries can recover as third-party beneficiaries. They explicitly overruled the old privity barrier from Buckley v. Gray, granting standing to non-clients in these specific drafting scenarios.
That is a monumental win for the plaintiffs. It fundamentally changes the landscape of professional liability. But, and here's where the story takes a massive twist, winning the right to sue definitely doesn't mean you automatically win the lawsuit. Having standing just gets you in the courtroom door. So we need to ask, did the attorney actually commit actionable malpractice?
This is where we pivot to the standard of care for attorneys, because the law recognizes that professionals are human. By accepting employment to give legal advice, an attorney impliedly agrees to use such skill, prudence, and diligence as lawyers of ordinary skill and capacity commonly possess and exercise.
So it's not about being perfect, it's about being reasonably competent. Let's analyze Lucas v. Hamm on the malpractice claim. First, what are the legally dispositive facts?
The key facts here are that Hamm drafted a trust that violated the rule against perpetuities, as well as rules relating to restraints on alienation, specifically California Civil Code sections 715.2, 715.1, and 716. This specific error caused the trust to be entirely invalid.
And what was the core legal issue?
Does an attorney's failure to successfully navigate the rule against perpetuities constitute a failure to use the ordinary skill, prudence, and diligence expected of the legal profession?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule has three elements. First, the attorney must fail to use the skill commonly possessed by ordinary lawyers. Second, the error must not merely be a failure to guarantee the instrument's absolute validity. And third, the error must not be based on a question of law fraught with reasonable doubt among well-informed lawyers.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the failure to use ordinary skill?
The sub-issue is what actually constitutes ordinary skill when it comes to drafting complex trusts. The standard is measured against the general practice of the bar. The court looks to the general practice of law, noting that while drafting a valid will is obviously the goal, lawyers aren't infallible gods. Simple mistakes don't automatically plunge an attorney below the baseline of ordinary skill.
Understood. Now, what about the second and third elements regarding guaranteeing validity and errors on questions of law with reasonable doubt?
So we can look at these overlapping elements together. The sub-issue here is whether the rule against perpetuities is a settled area of law or a subject of reasonable doubt.
And we should probably take a quick detour here for you listening. If you aren't a lawyer, you might be wondering what on earth the rule against perpetuities even is.
Oh, it's the villain of our story, and frankly, the villain of many law students' nightmares. At its core, it's an ancient common law doctrine designed to prevent dead hand control. The law doesn't want wealthy people tying up property hundreds of years after they die, so the rule dictates that an interest in property must vest no later than 21 years after the death of a person who was alive at the time the interest is created.
It sounds like a math problem wrapped in a riddle, 21 years after some life and being. So if you write a will saying, I leave my estate to the first of my descendants who travels to Mars, that might not happen within 21 years of anyone currently alive, so the whole gift is just void.
That's a perfect example. It sounds simple in theory, but in practice, it requires lawyers to imagine every bizarre, hypothetical, impossible scenario that could potentially delay the property transfer.
So how did the court apply this to Hamm's mistake?
The court applied extensive historical and legal commentary. They actually quoted Professor John Chipman Gray, who wrote the definitive textbook on the subject. Gray called the rule a trap that seems to facilitate error, noting that its mode of reasoning is unlike anything lawyers are familiar with.
I love that quote. The leading authority on the subject is basically saying, yeah, this thing is a trap.
Exactly. He pointed out that eminent, brilliant lawyers frequently blunder it, and the court noted that California's 1951 legislation made a bad common law situation even more complex, explicitly creating a technicality-ridden legal nightmare. So the court concludes that because the law is so perplexing, an error here falls squarely within the reasonable doubt exception.
A technicality-ridden legal nightmare. That is a direct quote from the Supreme Court. They are fundamentally saying the law itself is the problem, not the lawyer. And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the holding, the court affirmed the judgment of dismissal in favor of Hamm. Because the rule against perpetuities is so famously confusing and treacherous, making a mistake on it does not mean the attorney failed to exercise ordinary skill. Therefore, despite winning the historic right to sue, the beneficiaries get nothing from the attorney.
It's a remarkable paradox. You win the battle of standing, but you lose the war of liability. To make sure this really sticks, I want to introduce a visceral hypothetical, because the distinction the court is making here is so important. Imagine hiring a professional, highly trained surgeon to remove your appendix. But while you're under, they accidentally remove your healthy kidney instead. That's a clear breach of ordinary skill. They failed at a basic medical procedure.
Right, they're completely liable. That's the equivalent of a lawyer forgetting to have the will signed.
Exactly, but now imagine a different scenario. Imagine hiring a doctor to perform a theoretical brain surgery in zero gravity using instruments made entirely of gelatin. This is a procedure described by experts as a medical nightmare. If the patient doesn't survive that gelatin zero gravity surgery, you don't blame the doctor's lack of ordinary skill. You blame the impossible nature of the task.
That analogy perfectly mirrors the court's view of the rule against perpetuities. The zero-gravity surgery is the exact legal environment Hamm was forced to operate in. It brilliantly illustrates the policy that professionals are not absolute insurers against all errors, especially when operating in traps for the unwary.
It's just such a wild outcome for those plaintiffs. Imagine losing $75,000, taking it all the way to the Supreme Court, changing the rules of contract law forever, and still walking away empty-handed.
It's sobering, but it provides an incredibly clear framework for how we analyze professional liability today. In fact, to ensure you can practically apply these concepts, whether for issue spotting on an exam or analyzing a real-world case, we can synthesize this entire module into a clear, step-by-step diagnostic checklist.
Let's do it. Walk us through how we should evaluate a situation where a professional messes up and hurts a third party.
Step 1. Check standing and privity. If a non-client is suing an attorney, identify if they are an intended third-party beneficiary. Did the contract's main purpose benefit them? Did the attorney understand this? If yes, they have standing.
Got it. Step 1, do they have the right to be in the courtroom? What's step 2?
Step 2. Define the duty. State the standard of care. Ordinary skill, prudence, and diligence. Remember, they aren't a guarantor of absolute validity.
Which leads right into the third step.
Yes. Step 3. Analyze the breach via the complexity exception. Evaluate the nature of the legal error. Is it a basic administrative failure, like missing a filing deadline? Or is it a failure to understand a famously perplexing doctrine, like the rule against perpetuities?
The kidney removal versus the gelatin surgery.
Exactly. And finally, step 4. Conclude on liability. If the law is settled and simple, the error breaches the standard of care. But if the law is a technicality-ridden nightmare where well-informed lawyers harbor reasonable doubt, the attorney is shielded from liability.
So, what does this all mean for you? It means that when you hire an expert, they owe a duty to those you intend to help, but they aren't expected to be infallible gods, especially when the rules of the game are a complete mess. It's a profound look at the practical realities of working within a flawed system. And I want to leave you with a final provocative thought. If a law like the rule against perpetuities is so wildly complex that even the Supreme Court admits an ordinary, competent lawyer can't be expected to get it right, who should bear the cost of that mistake? The innocent beneficiary who lost their inheritance, or the legal system that insists on keeping such a dangerous instrumentality on the books in the first place? Something to mull over until our next deep dive.